This
I know, I'm
conference will
kind of
now be
sweating 'cause I
recorded.
was walking outside talking, and I'm like, whoa, it's really warm.
Right, you're recording.
Is everybody in the room okay with me taking my mask off to speak? Okay, I just like to make sure because there's the exception for that in the mandate, but I want to make sure that everybody's comfortable. I do have this microphone, but I do have a quiet voice. So then you put a mask on top of it, it gets even quieter. So my name's Pam Whitmore. I don't know that I've met any of you in the room before at different meetings, but I work for the League of Minnesota Cities Insurance Trust. And I've got this fancy name that nobody knows what it means, but collaboration and mediation manager. So I'm a lawyer. I used to defend cities. And so now I work for the insurance trust and I go across the state and I work with council staff on conflict mediations, group facilitated discussions regarding team communications, best practices for decision-making roles, responsibilities, meeting practices, and open meeting law and data practices. So that's why I'm here to see you today. And he said whenever this, so for those of you at home, we just had something weird happen on our screen. So he said there's a box, so whenever I get this, I'm supposed to hit resume slide. So there we go. So just for everybody at home, thank you for having your mics off. If you want to ask a question, turn your mics on and please feel free to ask. This is interactive. I'm here to answer questions for you. The open meeting law is really confusing. So if there's a problem with the slides or something, also speak up about that, please. So I have to just say quickly before, I'm glad to be back in Grand Rapids because it holds a special spot in my heart. I spent a week up here 12 years ago when my now 21-year-old was 9 and he was in the Little League baseball tournament and they got second. So we stayed at the Sawmill Inn and we had to keep checking out and checking in because they kept winning. So you never know how long you're going to stay. And so it was, you know, it's fun to be back. So I took a bunch of pictures and sent them to everybody on that team when I got here today. So we are, and in case you're wondering, Shoreview beat us. My kids were Plymouth New Hope. It's very traumatic. But today, this is what our agenda basically is. So understanding the open meeting law, we're going to use a lot of exercises and activities to do that because it's boring to hear me just talk. And this is a topic that I tend to more just talk about. So please feel free to interrupt me and ask clarifying questions because the open meeting law is confusing and the application of open meeting law is confusing. So we'll go over the basic requirements and talk about the exceptions, but I really want to focus on some of those common issues that crop up. So the last thing on the agenda was where to get your answers. So where you can get your answers, of course, your city attorney is always a good person to get answers from. But we at the League and the Insurance Trust also have research attorneys on call every day. So if you have questions about open meeting law, they are available. You can just call our general number, or there's a general email box, or I'm also available too. So we are located in the state capitol and we provide your insurance coverage. So one of the coverages that we provide is open meeting law coverage. So that is actually a reimbursable coverage, which means that if there is an open meeting law claim that gets sued out, then we reimburse the city for the defense costs of that. So whether they win or lose. So it's not actually, the open meeting law violations aren't against the city entity, they're against the individual actors who would potentially violate the open meeting law because they're doing it in their role for the city. And so our coverage covers the city and the representatives of that city. So if there's an individual fine that's assessed onto the decision maker, then that is their own. That's out of their pocket. The insurance coverage does not cover the cost of the actual fine if there's a finding of an open meeting law violation. But the cost of defending that lawsuit is what's covered. Does that make sense? So that's who we are and why I'm here, because I, of course, want everybody to be able to get into the best practices of avoiding open meeting law. And as probably you all who have ever been involved in any type of, well, that's an open meeting law accusation, sometimes whether there's actually a lawsuit that's brought is not as stressful and time consuming as just the drama it causes in the public or in your community, or with each other too, as far as the confusion. So keep that in mind. When you're thinking about the open meeting law, the actual purpose of the open meeting law is put yourself in the public shoes. So that's the easiest way to think about it. So the open meeting law allows the public to get notice, requires the public to have notice when there's a quorum or more of decision makers of the decision-making body, when they're receiving, discussing, or deciding on official city business or official business of that governmental body. Okay, so the open meeting law gives the public the right to have notice of that and the right to be present. So if you always think of the open meeting law from that perspective, it helps. So the legislature wanted to make sure that the public has notice and they can be present. Okay, so that doesn't mean that you can't meet outside of a meeting as a quorum or more, but it does mean that if that happens, the public has to have notice that it's happening, and you have to have it in a location where they can be present and monitor it. Okay, does that make sense? So that's really the intent of the open meeting law. So as you can imagine, there's all kinds of questions that come up. Well, what actually is a meeting? What constitutes a meeting? Are there exceptions to that? Because we see each other all the time at the grocery store or at the bar. Well, what can we talk about? What can't we talk about? So it seems like it's pretty clear cut when you're reading the statute, but then there's all the actual applications that become confusing. Just a quick note before we go to what we just talked about, those basic requirements. I'm going to talk about what the courts see as a meeting, but before we do, I want to just say a quick side note about the confusion that many people have with respect to the First Amendment and First Amendment rights and what the open meeting law requires. So the open meeting law is a state law that requires notice and public to be able to monitor when there's a quorum or more, receiving, discussing, deciding official city business. What it doesn't require is the public to have the right to participate in the meeting. So there's a lot of confusion about that. So, of course, nobody at the league is ever going to tell you that you should never let your public be, not participate in your meetings, like to never have a public comment, because that's good best practice. You're elected, you're appointed for a reason, you're representing your city. It's always good to hear from your public. So, but that's not required under the open meeting law. If you do have public comment at your meetings, and that's when the First Amendment kicks in. So you can't control what they talk about. It's a public meeting. You can control how long they talk. You can control where they speak from. You can ask them not to use offensive language or to not repeat what other people have said. You can't require that, but you can't control the content of what they talk about because that's First Amendment. So if you're going to let them speak, you can't control their content.
What if you have a public forum and then you have it also on the agenda and it's separate?
Okay, so I don't know, you had your mic on. So the question is, because the people at home I don't think can hear you. So when you ask a question, turn your mic on. Yeah. Mine's green. So I think there's a button yeah, so push that button right there and re-ask your question.
Okay.
Thank you.
So if you have it on the public input part and you have it on the agenda later, can you ask people not to, if they're talking about that specific issue, to wait
Yes.
until that agenda item?
Yes, you can, because that's not controlling their content. It's controlling the process of when they're speaking on it. Does that make sense?
Yes.
Okay. Thank you for the question. So what's a meeting? A meeting was defined by the court as a quorum or more of decision-making members of the body, so of the public entity body. So a quorum, if you have So you all are a statutory, so for your city council, your statutory A city, you have 5 council members. So oftentimes when I talk about open meeting law, I'll reference a quorum of 3 because I'm talking about a council of 5 because that's a majority. I understand you have a lot of committees and commissions, and we'll talk about how to apply the open meeting law to those. But just think of whatever you need on your committee or commission when you're voting, what's a majority or more, that would be the quorum. Okay, does that make sense? So if there is a staff person meeting with like a mayor and 1 council member, for example, the open meeting law would not apply to that meeting because there's only 2 of the decision-making members of that body, and there's 1 staff person. And the open meeting law does not apply to staff members. Does that make sense? So that's the quorum rule.
So the question would be, do you have to look at your bylaws about what constitute a quorum? If sometimes they're written to be at the meeting, those present versus those that are on the membership.
So the answer to that question is under the open meeting law, if you're a charter city, then yes, whatever the charter decides is the quorum. But for statutory cities and their committees, it's whatever the majority of or more of the decision makers, because the purpose is however many it takes to make that decision.
But decision makers present or the decision makers?
Well, so are the decision makers present interactively where everybody can see and hear, or are they present by telephone? Because it matters.
But what if they're absent? What if you have a 5-member and 3 of them are, well, let's see, 2 of them are absent? So what's the majority then?
Well, so if you have let's use the city council, for example, there's 5 on city council. If you have 3 council members present and 2 absent, is that what the question is?
Yes, but is it a 50%
So
of?
you have a quorum of the whole body there to be able to have the meeting and make decisions. So the open meeting law would apply to that meeting because am I answering your question?
Well, sometimes you have a problem getting people to show up to meetings, and it's hard to make decisions if you don't get a.
So that's going to be a different issue. If you don't have enough decision making, if you don't have a quorum present at the meeting and that's a quorum of the whole body, then you're not going to be able to hold your meeting.
Because sometimes they will change it to say those present so that they could always make decisions.
Okay. So so you're talking about maybe a committee or a commission.
Planning commission is what I'm on.
Okay. So you would need to look at, for how to hold a meeting, you would need to look at the statute, have the city attorney look at the statutes, and then whether you can policy around that and change what establishes a quorum. So that's actually to hold the meeting. But for the open meeting law, the quorum rule is going to be based on the total number of people on that decision-making body because it dictates wherever you're at. So whether you're at the gas station or whether you're at a ballpark, or if you have a quorum of more, so the number of decision makers who can actually vote and pass on a decision, that's what's going to dictate.
I'll have to check our bylaws and see what it says.
Well, so how many people are in your planning commission?
7.
Okay, so you're going to have to hold a meeting, unless your bylaws, whatever your attorney decides about the bylaws, it's going to be 5, right, at least?
I'm going to check to see whether the bylaws say present.
Okay,
or
so,
total.
but for open meeting law, that's going to, wherever anybody's at, it's going to be 4 or more.
Mhm.
Regardless of how many establish your meeting with reading of your bylaws with your city attorney. Okay, does that answer the question for open meeting law?
So there's a difference between the open meeting law and what you actually need to conduct that business.
I think there can be, based on the interpretation of whatever the bylaws are by your city attorney. The open meeting law, though, is always the quorum rule of the whole body. So whether you can hold a meeting or not, I would talk to your city attorney about that. Okay?
Next question. Are you there?
If you have 7 members on your decision-making board, the quorum is 4, right?
So that's where I would look at your bylaws
Okay,
to
but
find out what the,
if the bylaws are absence on what, or neutral on that, the
so
majority is
it would
4.
be 4.
Okay,
Mhm. Did I hear a question on the phone?
thank you.
Yes. My question is, okay, could I make the word township instead of city and the same laws hold?
Yeah, so the townships, we feel really bad for because their township boards have 3 members. So you always are, you've got just one other person and you're always at a quorum. So townships have a really difficult time complying with the open, complying with the open meeting law. Everything has to be, you have to be very careful on any types of discussions that are happening outside of any meeting, and you want to make sure that if those are happening, that there's notice provided to the public and they're happening in a place where the public can be present and monitor. Does that answer your question?
The same laws apply.
What's that?
Same laws apply for open meeting.
Same laws apply, yes.
Okay.
Yep.
How about
Pam, this is
digital meetings?
Oh, okay, I got 2 questions at once. What about the phone first? Is that okay? Okay,
Sure.
okay, go ahead.
Yep.
So whoever started out with Pam, this is.
that was Peggy I'm with Harris Township. Harris Township has a board of 5 and our quorum is 3, but there are many
Yes.
townships that have 3 members, board members, and their quorum is 2. So
Correct.
if that
Yes.
helps at all.
Yes, but the open meeting law applies to both. But it's good for me to know that there's townships on the phone because there are a couple things that the court has been a little bit more reasonable about with respect to townships. So that I'll bring up later. Question in the room.
Can you count a virtual person? Let's say you've got 2 members present and 1 on ITV or telephone or whatever.
Mhm. So if everybody can see and hear each other, then they can establish quorum and they can vote. But if it's just call in, then no.
They also need to be able to see all material.
Mhm.
They just can't be a visual if they can't see material that's presented. And that becomes a problem when you hand out addendums at the meeting, because how do the people that are virtual see that stuff and make decisions?
So, all right. So the next thing that oftentimes trips people up is what is notice for these meetings. So if you've got a quorum or more of your decision-making body getting together and you have to provide notice, what does that notice need to look like? So for your regular meetings, and again, this is city council, so if you're on a planning commission or other committee, if you have an annual meeting where you set your regular meetings at the beginning, just keeping that on file complies with the notice requirement for regular meetings of that body, okay? So a lot of cities will post the regular meetings still, and that's fine. But technically, for regular meetings, you just need to keep this on file at the primary office, the schedule of those meetings. If it's a special meeting, so anything other than a regular meeting is a special meeting. So a special meeting can be a workshop. A special meeting can be a meeting called to discuss a specific property. A special meeting can be meeting with me as a training session where you're talking sometimes about official city business. There is an exception for trainings where you're not talking about official city business, but for training sessions or meeting with outside people where your official business is being discussed, that's a special meeting. A special meeting can be a visit to like a location. If you want to take a walk to a certain location, that can be a special meeting. For any type of special meeting, the public is required to have 3 days notice of that special meeting, and you have to make it so that the public can access and monitor that meeting. Okay, so that is, the statute just reads days, so 3 days notice. But if the last day of the notice falls on a Saturday, a Sunday, or a holiday, then you go to the next day to count as that last day. Okay? And it gets mailed to anybody who's made a request to have notice, but it's also needs to be posted in the community bulletin board or where you post notice. It doesn't have to be published by law. It does not have to be published in the newspaper, but many cities do. It doesn't have to be put on your website, but if you put those on your website, you should do that. But the law is posting it. Okay. Emergency, oh, go ahead.
Planning commissions have site visits to private property.
Mhm.
Does the owner have to give permission for public, other than planning commissioners, to enter the property?
If you want everybody there, if you want a quorum or more there at the same time, then yes. Or you can just make sure that people do their site visits in less than a quorum.
Okay. So I'm understanding that a private property owner can't decline to let somebody enter the property if it's a planning commission site visit where there's more than a quorum present.
So you can have a public meeting in private property. So if people are going inside that property, if people are standing on the sidewalk and looking at the property, that's publicly accessible. There might be other issues as far as whether how accessible that truly is for public. However, if you're wanting people to go into the property or onto the property and around the house, that if somebody challenged it, now keep in mind when we're talking open meeting law, like I say many times, the skies don't open, lightning doesn't strike and say there's been an open meeting law violation. Somebody has to complain. But if somebody complained about that situation and you had a quorum or more of decision makers going onto private property, I think a judge would say that's a violation of the open meeting law because the public cannot access that private property.
To have the situation where the property owners don't like each other, and so the one wanted to come on and the primary property owner said no. So do you suspend the site visit at that time and say we can't
Go
do it,
less than a quorum.
or less than a quorum?
Just go less than a quorum.
Have some stand on the sidewalk and then,
Well, no, I
Some
think
going.
that would be a serial meeting and let,
Oh.
especially if there's any type of discussion, just have them go at different times, less than a quorum.
okay,
Emergency meetings, I never had to talk about them before. Now we have COVID. So they can be called due to circumstances. That's going to be a judgment call, whether it's able to have everybody on site together in a certain time frame. But the notice requirement under that is a good faith effort. So if somebody has on file that they want notice whenever a meeting happens, then you have to reach out to those people. In an emergency meeting situation, you of course have to reach out to your decision makers and make sure they know about the emergency meeting. But with public in general, it's a good faith effort. So whether that means posting something on the door or putting it on a website if you have your website up and running and easy to add to. So that's the emergency meeting situations. So let's do a quick exercise. Is this a problem? The school board closed a meeting to discuss the superintendent's performance. They wanted to make it convenient for everybody, so they just made it a half hour before the regular meeting. Is it a problem that they didn't provide notice since the regular meeting was already noticed? Yes. Yes, it's a different time and it's a closed meeting, so it's a different meeting. It's going to be considered, it's an add-on, a special meeting, so it needs to have its own notice for the time and location and date. 3 days notice. Yep.
but that doesn't mean they're allowed in the meeting.
No, not for a closed meeting, but I'm just talking right now about notice.
Okay.
Yeah. So another question, during a meeting, here's a walk by. So and I've had this question a lot. Say it's about nuisance vegetation is getting discussed in a regular meeting, council decides, or any type of meeting, even if it's a special meeting about the nuisance vegetation. Council decides, since it's only a couple blocks away, to take a quick walk by the property and see for themselves. Is that an open meeting law issue? Yes. And the reason is, even because everybody's at your meeting, and you can argue back, well, everybody knows because they're all here and we're saying we're going to go to the property, there might be somebody in the public who chose not to be at that meeting, but would have come if they knew that you were going to do the walk around. So again, putting yourself in the shoes of the public, that's considered a change of location for that part of the meeting. So there needs to be notice for that. Anybody have any questions? Yes. Okay, so now we have this wonderful situation that we're all working through together, COVID-19. So there are actually two separate statutes that have always been in place for pandemic times and meetings and non-pandemic times. So we're going to start with the non-pandemic times and what the requirements are for joining in that meeting by interactive TV. Okay, so the statute has been changed a little by our legislature because of COVID. So I want to make sure that we walk through this. So imagine that we're done with the pandemic. And so the Chapter 12 emergency has been removed by the governor. So if a council member wants to join remotely, or a member of the body, decision maker of the body wants to join remotely, that has to be done by interactive. So whether that's WebEx or Skype or any of the number of platforms where you can see and hear. All right. And so the public at that time can be present on the site. There has to be at least one member of the body at the location of the meeting. So this is, again, non-pandemic. So we're non-COVID time right now. So there's one member of the body who's actually physically present. Other people can virtual into that as long as everybody can see and hear, and as long as the public present in the meeting can see and hear, including those who are the remote people. So I know one city actually puts on the little stick, the monitor, and puts it on the council chair so that the public who sits in the public area can still see and hear everything that that council member has to say. The change that came with the legislature most recently last session is that now there has to be a roll call vote anytime somebody remotes in. So you have to do all your votes by roll call. If everybody's on site and in the location, you don't have to do roll call votes unless, of course, there's the other statutory provisions for expenditures of, significant financial expenditures, that has to be roll called. But if anybody on the decision-making body is interactively joining the meeting, then there now has to be a roll call vote. So that's a change. And the other change is, again, we're in the non-pandemic time now. If somebody is remote joining the meeting, then that person is supposed to be in a publicly accessible location. So let's say somebody's down in Florida for work and they want to be able to help establish quorum and vote, so they remote into the meeting. They are supposed to be in a place in Florida where public could come. I know that's goofy. It's goofy, but that's what the legislature has said. And then the note, so then when that happens, whoever posts notice needs to post notice that there's, Councilmember Jones is remoting in from this address, so that if anybody here saw that notice and wanted to go to Florida and join Councilmember Jones, they'd know where he is at, and they could sit there and monitor that remote in. Okay, so that admittedly is goofy, but that's the way the law is. Now there's an exception. So 3 times a year, if you're on military active duty, you can't be in a public location. But the legislature doesn't want you to have to not be able to have your civic duty if you're, a decision maker in a public entity. So 3 times a year, you can use the exception where you don't have to be in a publicly accessible location to remote join a meeting. They've also, because of COVID, have said 3 times a year, and after the emergency is removed, then if you have a health reason, a healthcare professional has advised that there should not be in a public place for personal or family. And I was pointed out that I spelled medical wrong. Sorry, that should say medical situation. They can remote in from a non-public location. So think about that logistically though. If you're a council who meets, let's say 3-4 times a month, you've used up that exception in 1 month. Because it's only
I have
3
a
times.
question.
Yeah.
When you're talking about council members and remote locations, does that also apply to commissions and boards?
So if your commissioner board is subject to the open meeting law, then yes.
So I
so-
have a question, I guess, or comment.
Yep.
We've had somebody that has participated remotely at a commission meeting. I don't think she's been in a public place when she's done this.
So it's pandemic times right now, so that's now allowed. If it's during a non-pandemic time and your commission or committee is of a nature that would be subject to the open meeting law, which is very confusing because the courts have decided some that have, but they haven't, given a huge list, right? So I can give you some examples of some commissions and committees that the court has decided is subject to the open meeting law. Otherwise, they have a broad standard of whether it's a decision-making body or not. So we'll talk a little bit more about that, but let's say that it's a planning commission. So the court has specifically said that committees or commissions that are subject to the open meeting law, planning commission, EDA, HRA, Fire Relief Association, the state auditor has given that opinion. I don't know that a court actually has yet. What's the Public Utility Commission like you have, which was created by City Council. There's another type of Public Utility Commission that's created by a different state statute that's not subject to the open meeting law, but Public Utilities Commissions that are created by City Council a court has said is subject to the open meeting law. So those are the ones that we know for sure. The ones that get more confusing would be a fact analysis by a court of whether they're a decision-making body. And so courts would look at how they function, how often they meet, the recommendations, whether the recommendations generally are always accepted or not accepted. And then they'll make the determination that it's a decision-making body. And then they'll say that's subject to the open meeting law. So since it's so blurry, for lack of a better word, the conservative approach is if it's a standing committee that is of the city, then treat yourselves like open meeting law. Now, to the question of the caller, somebody's got to complain, right? Somebody's got to actually be interested in your commissioner committee and complain about it. But if they complain, then it's going to be an analysis by the court of whether your commissioner committee is subject to the open meeting law. So if it's a non-pandemic time, then they should technically be in a public location. I can't sit here and honestly tell you that every single member of a decision-making body complies with that all the time. But that's what the legislature requires. Does that answer the question from the caller?
Sort of.
Sort of. So what's not clear?
Well, okay, I'm on the Police Advisory Commission. To my knowledge, we do not make any decisions. We don't have any authority.
I'm sorry, what was the commission?
The Police Advisory Committee or
Okay.
Police Citizen Advisory
Yep.
Commission.
Mhm,
We have
yep.
no authority.
Mhm.
I guess we can probably make recommendations. I'm not sure about that either. But we've had one member this past year who joined us
Mhm.
remotely. But she did
Mhm.
it from her home or wherever she was located. She was on a job.
Mhm.
So I guess I'm wondering when we resume meeting again, which will happen this week, she's going to be in attendance, but I expect that she will not be in, off and on through the winter months.
Mhm.
Is she going to have to be remote from a public place, or can she do this from her home?
So here's what I would recommend. It's a standing committee, but you're not sure whether it's a decision-making standing committee. I would ask the staff to check with the city attorney and get an opinion on whether that commission or committee is subject of the nature to be subject to the open meeting law.
Okay.
Because then you have a legal opinion which covers the city if there was any types of later action. You can go back and say, we ran it by our city attorney. They made the determination that it's not of the nature to be subject to the open meeting law. Again, it's always a good idea, just a best practice for public perception type, how you're viewed, to have your meetings be open. But whether that person needs to be in a public place, if you want to get that detailed analysis, I would really look to the city attorney to make the determination about whether that's the type of commission that would be subject to the open meeting law.
Thank
Because
you.
if the answer to that question is yes, then they should be in a remote, publicly accessible remote location in non-pandemic times.
Okay.
I have a question.
Yep.
What is the concern with somebody being in a private remote location?
Because public can't be there to monitor
What are they going to monitor?
that person as they're participating in the discussion.
They can see them.
It doesn't matter. The legislature says that the statute gives them the right
Mhm.
as a public member who
Okay.
elected, or I know that there's appointed standing committees, but that they have the right, if they choose to monitor that individual person's conversation during the meeting, then they can do that.
So the state feels that seeing the person and hearing the person is not enough.
You got to remember, this is a legislative body who made these statutes, and I mean, sometimes there isn't a lot of reason to some of it.
Okay.
I mean, logic and what the actual statute says does not necessarily always go hand in hand.
Okay.
So,
Second one, follow up to that is, when there is a complaint, who is the complaint to?
so what generally happens is the process. So anybody can make a complaint of an open meeting law violation. Most often we see them from media or residents who are upset about a situation, but they don't have to be a resident. So let's say there's somebody on the East Coast who doesn't like something that happened in one of your meetings, thinks there's a violation, they could file a complaint. So filing a complaint would be a notice of complaint to the city that's under the litigation process. And then they would, an attorney on their behalf, or if they were doing it pro se, would then file a complaint with the court, the district court that is so a state district court that's oversees your jurisdiction.
So it goes both to the city and to the state?
Well, so the statutes outside of the open meeting law, the statutes require if somebody's going to sue a city, they have to give notice to the city that they're suing them.
Okay, so the notice is, the city is just noticed, but they're noticed that there's going to be something
Right.
in court.
And then when the actual official document that's called a complaint is served, it's served on the city. So it's in either a mayor can accept service or the key administrative person in the city can accept service on behalf of the city. So that's just litigation in general, whether it's an open meeting law, whether it's a slip and fall, whether it's, suing an officer, whatever, that's the process of how cities can get sued. Okay, so interactive TV during pandemic times. So Right now, anybody can virtual into meetings because we still have that Chapter 12 emergency that's in place. Making the public present, oh, here we go again, the thing flipped again on me. You see resume from present slide? Is that, my eyes are so bad, I'm gonna give that a try. I wish, no, that's not it.
Back one more, it should be from current slide.
Yeah, where do you see it? Because I
That's the
honestly, my
second-
eyes are so bad.
Second one from the left.
Second from the
Or-
Perfect, thank you. Sorry, I'm getting old. So the public, for right now, if public, it's distancing, but also monitoring remotely will meet those criteria because the criteria under when there's a pandemic for public monitoring is to the extent practical. So not every city has the technology that's required to monitor, to see and hear. So during a pandemic, monitoring by telephone for the public is acceptable. So again, these other things need to be met though. There has to be a determination that it's not feasible to have an in-person meeting. Members of the public have to be allowed to be present unless there's a determination it's not feasible because of the health pandemic for them to be present. And then you have to make the monitoring as practical as possible. Again, the other things apply to for that roll call vote.
Question, if somebody wants to be present virtually, somebody, a member from the public, and you don't have those capabilities,
So are we in a pandemic time or a non-pandemic time?
well, let's say we're in a non-pandemic time.
So you have to make it so that the public can monitor,
So you'd have to go out and buy things to make it doable.
or you have to let them be in the room. I mean, if it's a non-pandemic time,
Let's say they're in Florida.
nope, you're not required to. All you're required is if you're having a meeting, you have to have it in a place where people can show up.
Right.
So the meeting is actually happening in the city of Grand Rapids. So it's a non-pandemic time. You just have to make sure the room can accommodate public. You don't need to make sure that there's a call-in number for a person of your public who happens to be out of town.
And for a pandemic time,
So for pandemic time, it's as practical. So it's really going to depend on the capabilities and technology of each city.
so you could say, no, we don't have that capability.
Yeah, and if somebody wanted to challenge it, then you'd have a judge involved determining whether your budget really truly would allow whether it was practical or not practical.
But with all the monies out there for COVID stuff, I would assume
That
best
one,
to
I
go-
can't make a judgment call
Okay.
on that one. Okay, so continued meetings, the time and place, if it's been stated in the original meeting and you don't adjourn that meeting, then you don't need to give notice again. Okay, so if you're in the course of the meeting, you say, we're going to continue this time, this date, then you don't have to re-provide new notice.
How is that done to be continued? Is that a motion, a second?
Yeah, you need to have that on a motion second passed by
Is
majority.
that the same as tabling?
No, because you're continuing the whole meeting. Tabling is you're tabling an issue or an agenda
Okay.
item. So we talked about, so I want to make this for your session, but I'm worried about people's time too. So I'm going to maybe scooch a little quickly. So if I'm going too fast, please stop me. We talked about accessible, so, and we really talked about this. If you have this is actually a case, school board provided advance notice of a meeting, but it took place in a private office and outside the school district's border, so that since it's at a private office, the public couldn't show up. The other part of that issue, and it actually happened, is that, and so for my township people on the phone, the court has been kinder to townships on this than they have been to cities. So this really is going to be a fact analysis by the court. But our data practices office, which is an administrative office of the Department of Administration who gives opinions on the open meeting law, since it can get so confusing, They have said if there are capabilities to have your meeting at public places within your city, then that should happen. Now, townships, they have been more lenient on because it's not practical or doable to maybe have your meetings in a township based on the facilities. So, but this was a finding by the Data Practices Office. There was, St. Anthony had their goal setting meeting just in Brooklyn Park at a hotel that could accommodate public. But the Data Practices Office said, nope, it's in another suburban city. You had the capability to have it in your own city. And so that would not be okay. So just so you know. Closed meetings. So we always say, talk to your attorney. There are only 7 reasons to close a meeting. I'll have those listed in a slide coming up. But people get confused on how to notice closed meetings. Well, basically, you notice closed meetings the same as if it was any other type of meeting. So let's say you have a closed meeting that's a special meeting, that would have the 3-day notice. And so all closed meetings start in an open meeting. So everybody gets to the location, they open up the meeting, and then you close it for a specific reason. And it has to be a member of the body who actually closes the meeting. So let's say it's a performance review. So you open up the meeting, motion second, opening the meeting, and then say, now we are going to go into closed meeting to do the performance review of Sally Jones. So that's how you have to, and it has to be a member of the board. So you have to be specific so the public knows what the closed meeting is about. So lots of cities think that when you can't say the employee's name because they think that that's not public data. But in fact, when you're closing a meeting to give a review of an employee, you actually state the employee's name. Okay. That employee for a performance review, if that's the reason you're closing the meeting, they need advance notice of that because they have the opportunity to have it open. That's up to them. So here's the reasons to close. So on these, it says must or may, because that's how the statute reads. But I can't imagine that under those may close would ever be a reason why you would not want to. All right. Labor negotiations, if you have unions, so that's not going to apply to all the committees and commissions. But if you're having labor negotiations, you can close the meetings to have the discussion on the contracts. And then when you come back to open meeting, that's when you actually vote on the contract. And then the data that is provided after those meetings depends on the content of the meeting. Okay. I'm going to skip over attorney-client right now because I think it's the most litigated one, so I want to spend a little bit of time on it. But employee performance review, we talked about. Purchase the sale of property, that's any type of property, not just real property. So that makes sense, right? Why would the city benefit from telling everybody what they're going to accept on property? So that can be closed. Security data, you're putting in a new security system at City Hall. It's not going to benefit the security if everybody knows how it works or where the cameras are, so that can be closed. You have to close meetings if there's misconduct, allegations of misconduct against somebody under the council's authority. All right. So what does that mean under the council's authority? Employees, for sure, they're under the council's authority. Most likely appointed positions because the mayor generally appoints or council would appoint. So those are under council's authority. The bigger question, and I think the answer is no, they're not under council's authority, is other council members. So are the mayor and other council members under the council authority? Some city attorneys say yes, depending on how those elected officials are paid and if they get benefits. I would say the general answer to that is going to be no. So if they are under the council's authority, you must close. Keep in mind that's for discussions of preliminary discussions. So work with your city attorney. If you're closing a meeting because there's been allegations of misconduct, work with your city attorney on how that meeting runs and have them present, because what happened to the city of Tower just last year was they closed their meeting to have discussions of allegations of misconduct of somebody under their authority. And they decided in that closed meeting to have an investigation. So, and then they plan to have another meeting after the investigation to discuss the findings and have that further discussion about those allegations. But the Data Practices Office said that second meeting was no longer preliminary. Preliminary. So the statute actually reads preliminary discussions of preliminary discussions of allegations. So work with your city attorney so you don't run into that issue, and making sure that however, whether it's a continued meeting is probably going to be the safest way. You know, we're having this investigation, we're going to continue the meeting, as opposed to having a whole new meeting and then you have to fight the battle of whether those discussions are still preliminary or not. So it's kind of a little, just something that the Data Practices Office curveball that they threw at us. So certain non-public data, you really are, the police commission might actually. So there's certain non-public data that meetings have to be closed for, and those are, so not all non-public data, but certain, and it's alleged victims, mandated reporters of criminal sexual conduct, domestic violence or maltreatment, active criminal investigations, law enforcement officer misconduct, not public education data. So when I say not public, the statute actually will classify some educational data as not public. Not public health data, not public medical data, and individuals' medical records. So those are the only times based on the data that you have to have a closed meeting. So sometimes there's non-public data that might come out in a meeting for discussion that might be protected generally if someone did a data request that you couldn't give to that person making the data request, but the council has to talk about it in the normal course of business, or the planning commission has to talk about it in the normal course of business. You can't close for that non-public data. So if you ever have a question, talk to your city attorney or your responsible authority for your data.
Question.
Yep.
What happens when you're done with the closed meeting?
So
Does
then,
there have to be a disclosure during a regular meeting of what happened?
so it depends on why you closed it. So for example, you have to adjourn the closed meeting, then you come back into open meeting. And let's say that you had your labor negotiation discussion and you decided that you're going to vote on the contract. So then in the open meeting, you would do that vote in the contract. If there was a closed meeting for performance review and you come back into open meeting and you decide to give them a raise because they got a good review, that's an open meeting. So it's the actual decision that is public, but not the discussion. And so, for example, attorney-client privilege, which is the one that's most sued on, is supposed to be, is you can close for discussion of strategy for a pending or actual sued out action, okay? So you can't have on your agenda, we're gonna close the last part of the meeting to have the attorney update, okay? That's an illegal closed meeting. But what you can have is we're gonna close the meeting to discuss, you know, City of Grand Rapids versus Smith and the upcoming summary judgment motion. So then when you come back into open meeting for that, you're not going to discuss what you talked about because it's attorney-client privileged. So it depends on what was discussed in the closed meeting.
So what would the public get after a closed meeting on something like that? Would they just get a statement that, would there be any statement at all? Because a lot of times they end and nothing's ever said at the open meeting.
Not for attorney-client privilege, no. So it really depends on what the discussion is. If there's allegations of misconduct, you're not going to, and you decide to have an investigation, you come back into the meeting and say, you know, there's maybe an investigation that's ordered, but you wouldn't talk about the allegations or what was talked about in the meeting. You know, purchase and sale of property. If you come back and you decide you're going to sell the property, that would be public. You could say that, but you're not going to say, and we're going to take, by the way, we talked about that we're going to take $2 million for it, you know? So It depends. That's why with closed meetings, we always say, work with your city attorney. All of those need to be recorded because, except for attorney-client privilege, that's the only one that's not recorded. And the reason for that is because if there's labor negotiations, you agree on the contract, then all of a sudden that data that was not public when it was being discussed in the closed meeting, that contract's been signed now, so someone can do a data request, and so they can get that recording. They have the right to know what was said after it's been decided, and the data becomes public then. Does that make sense? Okay. Where's my little clicker? Okay, here it is. So the process to close, again, I talked about that. The big thing is making sure that a member is closing it and that there is enough information without violating data laws, but that the public knows why it's being closed. We just talked about that, so I'm going to skip by it for purposes of time. And because of your good question, Greg, we talked about this as well. So I'm just going to skip by that. So what groups need to comply with the open meeting law? This is the one that people get the most frustrated with me. So for the person who's remoting in on the police commission, I'm sorry. I can't tell you for sure whether you are or you're not subject to the open meeting law. Like I said, the court has stated HRA, EDA, that's statutorily created, Fire Relief Association. Those are standing committees that that the court has determined makes decisions. Planning Commission is another one. It's a standing committee that makes decisions in the court's view. The other ones, when they're considered just advisory, that's a call for your city attorney to make. The easy thing is, citizens come and say we want to do research and make a recommendation to the city on a skate park. Well, they're not going to be subject to the open meeting law. To be safe, if there's any standing commission that is continually updating or making suggestions, then treat them as a subject to the open meeting law if you want to be conservative and safe. But otherwise, if you have those situations where people are remoting in and you're worried about having violations, you can certainly clear it with the city attorney as far as what the city attorney would legally opine, whether a judge would find that to be a group subject to the open meeting law or not. So the other question that comes up a lot is when decision makers of one body attend a committee or commission meeting, and whether that's two meetings layered on top of each other. So if you have, let's say, I know earlier today I had somebody who was on the PUC who was also on council. So let's say that person is at their PUC meeting and two other council members decide they really want to know what's going on with the PUC, so they just show up. That technically could be seen if they participate in the meeting, ask questions, talk to each other. That could be seen as an open meeting law violation. Now, do they have to avoid doing that? Well, if they tell the person who provides the notice to say, hey, we plan to be at this meeting. Will you notice that a quorum or more of the council will be attending the Public Utilities Commission meeting? There will not be official city business decided. She or he can put that in their notice, and then it's fine. Then it's not an open meeting law violation. If you have a drop-in, there's a couple ways you can handle it. You can come into the meeting, you can say, oh, okay, I'm doing a head count and there's two other of my colleagues here. I'm making a quorum, so I'm gonna leave. There have been cases where that situation where there's been a quorum or more attending a meeting and they have sat away from each other and they haven't interacted with the discussion at all. And the court has said, that's fine. But that is not going to be your conservative approach, because you're hearing official city business. The cases, though, that have found that to be a violation of the open meeting law have been really egregious. So just a couple years ago, there was three council members who came to, I think it was a planning commission. And yeah, it was a planning commission meeting. It was in '93. City officials in Afton went to a planning commission meeting. There was a document that had been handed out to public, so they had it. They all conveniently left at the same time and were gone for the same amount of time. Somebody saw them in the coffee room looking at the document together. The judge said, they're having a meeting within a meeting. So that was an open meeting law violation. So it's pretty egregious. For my township boards, there was 2 members of a township board that attended a county planning commission meeting and heard but discussed the matters with the township board while they were there, and the court found that to be a violation of the open meeting law. So again, it's going to be an analysis of how much interaction those council members had. There's also another case where the 3 city council members, it was a council of 5, 3 city council members were talking in the parking lot after a commission meeting, and that was found to be an open meeting law violation. So just keep that in mind. There can be, if you know you're all going to be there, just have the notice. If you have a drop in, just stay away from each other and don't participate. So staff, open meeting law does not apply to staff members. So if you're wondering how you can get information to each other before the meeting, a really good way to do that is to send it to staff and have staff send it out to everybody. Just here's what I found out. Let's say you're talking about mosquito spraying. Here's what I found out about the chemicals for mosquito spraying. Send it to a staff person. The staff person can send it out to everybody on the decision-making body. You're going to have better discussion during the meeting, right? What you can't do is you can't have the city staff person poll everybody. Like, I want to change the chemical in the mosquito spraying. Find out who would vote with me and who wouldn't. That is effectuating a decision or discussion that the public should have notice of and be present for. So that would be an open meeting law issue.
A question.
Yep.
What if a staff member takes it upon themselves to do that and communicates such information? What is that considered?
So if you knowingly have a staff person, if you as a decision maker I would ask the staff person, have you asked this of other people? This open meeting law is on me as an individual official. If the staff person's talking to 1 person or 2 people or less than a quorum, that's going to be fine. But if they're talking to a quorum or more and you're concerned about that, I would stop them from having that discussion, just because it puts it on you. Because the open meeting law, the fine goes on the actual decision-making member. So
if a city staff person or any organization under this law were to say, talk to 4 other members or all the members of a commission and say, oh, the other ones all support this, say, planning change, they would have then forced a violation on all of the committee members, is what I'm hearing you say.
if somebody found out about it and if somebody brought an action about it, then the court, I think, would look at whether you knew that they were had talked to the other people and whether you then willingly engaged in that conversation. So there's a lot of ifs down the road. A lot of the open meeting law is getting into best practices. So staff really should just be giving information out and receiving information, but shouldn't be polling or effectuating any type of decision making. Does that answer your question?
Another question I might ask then, could a community member take it upon themselves to poll committee members on a topic? Because of course, community members would certainly do that. And then say I've talked to the 5 other city councilors and they're telling me they support this sidewalk shoveling. Then I imagine that would also be a violation because of the community member, correct?
Well, yeah, so Again, the open meeting law does not apply to community members. You can't control what they tell you. I think what the court would have an issue is if you said to them, yeah, I'll support that. Will you call the other 4 people and find out if they'll support it or not and let me know? I think that that's where you're going to have the issue. It's the same type of fact analysis that even with the staff person, if you're willingly engaging and encouraging that person who's not subject to the open meeting law to effectuate a decision or a discussion outside of a meeting. So it's going to be a fact analysis. It's just good practice to stay away from it, but you know, we all know you can't control what public says to you.
Thank you.
Yeah, it's hard. All right, so again, this is a real case. Sorry about the lack of a space between the and Minnesota, but this is egregious as well. So you can see a lot of these cases are really the courts looking at it and saying, okay, that's not even a close call. The administrator talked to each of them, figured out what each of them would be okay with, drafted the letter, sent it to each of them, they signed it, and then they sent it to the MPCA without it ever being discussed in a meeting. That the court found was a staff person effectuating the decision without complying. And the unfortunate thing in that situation, the fine was on the elected officials and not the administrator. So, because that's how the law is written. Pre and post meeting discussions, be careful of these. Of course, the obvious ones are you're not going to gather at the coffee shop and talk official city business. Or I had one city where they were gathering at the antique store. And, you know, were they talking official city business? Who knows? Nobody actually sued on it, but I'll tell you what, the public talked about it all the time. And you had people who were watching to see which trucks were in front of the antique store, and it took up so much. And then they'd call staff and they'd be, you know, so-and-so's trucks outside the antique store. And the staff person's like, I'm just trying to get the utility bills out. You know, I don't have time to. So think about that too with the open meeting law. That can cause a lot of drama and time spent that way. So when you're discussing business outside of meetings, people are going to be very aware of what you're talking about, you know, so that's the pre and post meetings. The other thing that people don't think about is when after you've adjourned a meeting and you're wrapping up, don't talk about official city business because the meeting's been adjourned. And so, you know, maybe public's left or so we actually had a city where a council member sued his fellow council members because he was sure at the end, he was always in the minority vote, and he was sure at the end of the meeting that they were talking about official city business because they were pointing to the screen or something, or moving their hands where he figured pointing to the screen. It actually got sued out, went in front of a judge, and the judge said, well, there wasn't any proof that what they were talking about was official city business, but if there had been, there would be an open meeting law violation. So even though you just got done with a meeting, stay away from talking about business, and that includes out into the parking lot. You never know who's around. So, all right, so we're just talking about that. So those discussions afterwards, serial meetings that's really a big source of confusion because it is, maybe you're not all together at the same time, but you're talking about the same piece of business, one right after the other. And so that has been considered a meeting by the courts. It was a school board case. They were reviewing it was a superintendent, and they were reviewing that performance, and they wanted to know whether they were going to be all on board about discipline. And so the president of the school board called another member of the school board, and then they, you know, you call the second person. And so that was considered a meeting. Now, what I cannot answer for you is what period of time can you wait in between before, let's say, I talk to Greg about official city business, and then, you know, a week passes or a month passes, or maybe we have, you know, a meeting in between. And then I talk about that same piece of business with Annie. Well, so the answer is, I don't know, because there's nothing that has been decided, or that's not clear in statute. There hasn't been guidance from the court. I would say, in my personal opinion, what a court would say for sure is if there hasn't been a meeting in between, then they're going to find that that's a serial meeting. Because it hasn't had a public forum, so to speak, where that can be discussed. But there isn't a specific time period. And keep in mind, these serial meetings, the court's not going to care whether you're doing that in person. You know, I'm going to talk to you in person, you talk to somebody else in person, or if you do it on the phone, or if you do it via email, or you do it via text, the court's not going to care. If you're having that type of discussion about the same official business and it's serial like that or daisy chain, the court's going to find that as a meeting. So that's where you got to be careful. I know in many cities, it really falls on the elected official, because you're going to have, especially the mayor. I feel very sorry for mayors, because the mayor's going to be that center point of one person calling saying, well, how do you think the meeting went? What about this? And then that mayor, if that's two people, that mayor can't talk about that issue with any other of the council members until, you know, there's been an official discussion about it that's public's present and has had notice of the meeting. So it really falls on the decision maker to say, I've talked about this with somebody else already, I can't talk to you about it, you know. So it sometimes makes it difficult because the burden falls on you as making that judgment call.
Can I ask a question?
Oh, yep.
I'm township again.
Okay.
Townships are small groups, and we're
Yep.
often neighbors. So it often happens that two of our three supervisors might be at dinner together. Some other friends. Do they need to be very careful not to talk about anything, say the road stuff that we put down?
Yeah, so this slide that's up now is social gatherings. So yes, you can have dinner together. And I know I'm getting rolling of eyes from people that I can't see, but the courts, if they really analyze the situation, it was a fact situation, you had a big discussion about a development project or roads or something, they're going to find that's a violation of the open meeting law. So you do have to be really careful. It makes it really hard, especially with townships that have a 3-person board. So yeah, I wish I had a better answer for you. Be careful. And it also, the other thing, I mean, and I shouldn't say this as a representative of your insurance trust, but the other part of it is, you know, within reason, who's going to know, who's going to report you, and is public going to see? So I absolutely say stay away from official business, but if there's a slip up once in a while, I don't want you sitting there and fretting about it, because you know, don't intentionally talk about official city business, but also, you know, the cases that are actually sued out on open meeting law are not as often as I think people think they are, because they get written about a lot with the media and people who are upset. So a big part of the open meeting law is public perception. You know, there's lots of councils who have spouses who are on council together. So let's say that's a council of 5, you got 2 living together. So they have to be extra careful. If there's another friend of theirs who happens to be on council too. So don't stop living your life, I guess. Just be cautious. Yeah. So there are other exceptions. League training, your exception, you can be in a quorum or more at league trainings without having to notice it. Social gatherings, as long as you're not talking official city business, again, you got to think about the public perception in that. And then team building, that's a tough one for me. So I will go across the state and do a lot of communication and team building. I always make sure those are noticed, because then if somebody happens to talk about official city business during the team building to improve how they interact together as a team, I don't have to worry about it. But technically, team building is an exception under the open meeting law. Okay, I'm coming down on 10 minutes here, you guys. So I want to be respectful of your time, but let me know if I'm going too fast. Oh, you can stay here till 5. I will be driving at that time. Interviews for those of, I know that's not going to be relevant to everybody, probably mostly just to city council and the township boards for interviews. Are those subject to the open meeting law or not? Well, if you're interviewing as a quorum or more, then yes. So oftentimes cities will appoint and delegate some of the responsibilities. You cannot delegate hiring and firing. But if you want to delegate interviewing to a personnel committee, that will be less than a quorum, then you can have those initial interviews or those interviews in a non-open meeting law setting. So that's why many cities will have personnel committees that will be a key administrative person and then maybe the mayor and sometimes one other council member. Okay. We talked about electronic communications. You know, the reply all is, there's a lot of people who get really spicy with me about email because that's the best way to communicate, right? And so keep in mind that I'm conservative with respect to the open meeting law and best practices. And this is an area where people can just easily trip up without meaning to. So the court has said that one-way communication is not a violation of the open meeting law. So staff can have communication with all of you, but a decision maker to decision maker, one-way communication, if it's to a quorum or more, is not technically a violation of the open meeting law. The thing you have to worry about is if people start replying all, and there's a discussion that happens. And if somebody gets wind of that and reports it, then that can be found to be an open meeting law violation. So best practice is, you know, if you have a one-way communication out to your other decision makers on your body, is to just do a BCC so they can't reply all. The other thing to keep in mind though is if somebody is emailing you right back and brings up something like, and if it's something that's more than operational that you've emailed out about, then you're setting yourself up to have people reply right to you. That could be a serial meeting. So I understand there are lots of times when you have to schedule meetings, right? If there is, yep.
You said more than operational. Could you please say a little
Yep.
more about what that means?
Yep, so that's what the court has said. So there's actually been a case, and there's only been one case since the open meeting law has been passed. And the court in that case, it was a scheduling issue. And the court said that that wasn't a discussion of official city business that was substantive, it was operational. So that did not violate the open meeting law. But that's going to, again, be a very fine line to walk. Like, is this discussion operational or is it going to be viewed as something of substance? So if you want to just not have the stress of it, then don't reply all to everybody. Or use staff to send out the information you want to send that might be more than operational. The court has found that one-way communication about I've scheduled the meeting for this date, that's not going to be a violation of the open meeting law. But there was the data practices office found, I think it was Birchwood Village, where the mayor had sent out, we're going to have the meeting on this date, or are people available on this date? And then people replied and said, yes, by the way, can we add mosquito spraying to the agenda? And somebody else said, well, why are we talking about what's wrong? Is this chemical bad? I read about this chemical on the bees. And all of a sudden that's a discussion that was not noticed to the public. So then the data practices office said that was an issue under the open meeting law.
Question.
Yep.
So the can we add wasn't necessarily the violation, it was the subsequent discussions.
Right.
That was the violation.
Right. So that's why when I say that one-way communication out, the court has said that's fine, but you're setting yourself up for the possibility that you can't control of a discussion happening. So it's just best practices. You're not going to get into any trouble if you just use staff to distribute out that information. So just keep that in mind. So this again applies to text. It's questionable whether it applies to social media discussions on posts. It has not been decided yet. There's a state statute that exempts decision makers, elected officials, from being subject to the open meeting law for using social media in general. That's fine. What the Data Practice Office has hinted at, but hasn't been specific and a court hasn't decided, is if there is a post, let's say there's a Facebook post, hey, did anybody see the new playground equipment? Go check it out. And then 2 others or enough to make a quorum have discussion on that post. Why did we end up paying for that? When's the grass going to be filled in? And another one says, well, I don't think we decided on the grass because we were deciding between this type of grass and that type of grass. All of a sudden you're having a discussion on a social media post. It hasn't been decided. But I would say if you just best practice, stay away from having any types of discussions on posts in social media.
Yeah, because we have a neighborhood watch Facebook thing that a lot of people, that's how they communicate things, and there are council members on there as well.
So I think they can be on there. I think the biggest thing is if they start having council business that's being discussed together on one post. All right, here's this touches on it, and this is a question I get a lot. So, when you want updates in between meetings, this is common request of people who are a part of a decision-making board. They want to have updates of what's going on in between the meetings. And so if the staff person's doing that, that's fine. There's not going to be any issue of that. Sometimes you don't have the staff to be able to handle doing that. So again, if one of the members of the board wants to send that information out, and that's going to be absolutely necessary for that community to function, I would do one-way communication. I would do BCC, and I would put in the text of my email, please do not reply to this. This is for information purposes, one-way information purposes only, so that it's in that email text or email communication. That makes sense? Okay. All right.
What is BCC?
So below carbon copy. So when you have your email up, mine automatically comes up. Some people have to click on a button for it to be able to come up, but it's below carbon copy. So what happens is so oftentimes I'm communicating with whole councils when I'm setting up trainings. So I'll put my name in the two, so it comes right back to me, but I'll below carbon copy all the elected officials. And so they don't know that, that it all went to everybody. I'll say in the text, this went to everybody, please don't, reply. They can't reply all the way that BCC is set up. It can only come back to you. But with elected officials and members and the concern about you being the one who's part of a serial meeting, you might want to put in the text of your email, please don't reply to me. This is purposes of informing you, information only. Now, of course, if you get a thank you back or whatever, that's not going to violate the open meeting law, right? So it's just really getting into good practices. It's not really, it's not shutting down your lives, right? Even though it feels like that sometimes. Okay, what about somebody who's on a cruise? Can they call in? Well, I think it would be pretty hard for a person who's not on that cruise to get to that cruise. So no, this would not be, they could call in and just monitor the meeting, but they wouldn't be able to participate in voting or establishing quorum. I'm going to skip through the phone one. We talked about that. So personal liability, we touched on this at the beginning. Just keep in mind that there is a removal provision. So if a court, it has to be a court or a judge, finds 3 separate intentional violations of open meeting law, then the decision-making body, obviously most often the council it comes up with, can have the discussion and remove that individual. But the court has stated that it has to be 3 separate intentional violations that are part of separate transactions. So separate, basically the court wants to give the decision maker the opportunity to learn and be better. So in Funk versus O'Connor, there were some of those elected officials whose fines were in the range of $6,000 to $7,000 because they had that many open meeting law violations. It was a development project and they were meeting with the developer outside of it being noticed and public accessible. So that was more than 3 violations of the open meeting law, but the court said, no, you can't remove them unless it's in 3 different separate adjudications, because the court wants to give people a chance to be able to learn, and that all happened during the same development project. Does that make sense? I think there's, in Minnesota, I think there's only been 1 person removed, and I'm sorry, township people, it was a township person. It was a long time ago. But that's the only time I've known of a removal. Okay, so we're pretty much to the end. I have a couple little things that people get confused about. Oh, I'm going the wrong direction. So open meeting law requires a public body to provide advance notice of its regular meetings. Who wants to chime in? True or not true?
Yes.
So it's my trick question. So the notice will be on file. So you don't have to provide notice every time of a regular meeting. So you have to always provide 3-day advance notice for special meetings, but for your regular meetings, it would be on file. So that's my only trick question. Lots of people ask this question: does the open meeting law require rules of order or parliamentary procedure during your meetings? Okay, I'm just going to say I had somebody shaking their head no in the room, and that's absolutely correct. It's not a requirement, but there's a lot of people who think that there is. We talked, so what about this one? This is one that's probably my most common question. Let's say that there's been a finding of an open meeting law violation and then the later action by the public body. Can that be reversed?
If there's an open meeting violation, doesn't that mean any actions are null and void?
No. So that's the interesting part of the law. You have personal liability and fines, but the actual decision, because that decision, for it to be an official decision, is going to have to be on a motion with a second and a majority vote. And so the courts have said the decision stands, even if there's open meeting law violations that led up to when that motion got made. So the decisions still stand.
So if the public doesn't have an opportunity to hear or have discussion on that particular issue, it still stands.
Well, so this is talking about decisions that were conducted at meetings later. So for example, in that Victoria case, there's a lot of discussions about the development project and probably decisions that were made, but the actual decision on the project itself or on funding, different funding sources of that project, that was made at a meeting. And so there was a motion and a second and a majority vote that passed that development project that was made by the council. And so even though council members were meeting with the developer up until that point, it doesn't invalidate the actual council decision.
But if the decision was made at a meeting where there was an open meeting violation,
It still stands.
still stands.
Yep. So it's just that the individual decision maker has the potential for having the fine and the removal if it happens enough times. Yep. So I'm done. Any follow-up questions? All right. Well, thank you to everybody on the phone too, who virtual in. I can't see you because my PowerPoint's up there, so you're not technically on the phone, but I appreciate your time.
Thank you.
Yes, thank you. That's